Well, good evening, everybody, and welcome to Gray's Inn on a wet and windy night, not only to the students and barristers here, but also to those watching remotely, and to everybody who will be watching the recording of the event, because it is to be recorded and to be published, all being well, on a Lawyer Rights, perhaps the day after tomorrow. Unless, of course, anybody says something they shouldn't, in which case it'll be published tomorrow. Our topic is the independent review of the criminal courts. What does it mean for the criminal bar? And I must congratulate Gray's Inn on the timing, because the second and final part of Sir Brian Leveson's review was published just short of a week ago. To discuss the issues, we have a very distinguished panel of silks. Her Honour Wendy Joseph in the middle, in the presiding judge's position. She practiced at the criminal bar for over 30 years, became a circuit judge in 2007 and continued sitting on criminal trials until 2022. She was only the third woman to hold a permanent position at the Old Bailey. She's written 2 superb books based on her experiences as a judge. They're lightly fictionalized, but entirely true to life, and I can recommend them. Here at Gray's Inn, she was Master of Students, and she's always been a very strong supporter of the Inn's educational activities. On her right is Mark Fenhalls KC, a leading criminal practitioner at 23 ES Chambers, which are now based here in Gray's Inn. He was chair of the Criminal Bar Association 10 years ago. He was leader of the South Eastern Circuit 6 years ago, and chair of the bar 4 years ago. And then nearest to me is Professor Cheryl Thomas, who is the country's leading expert on trial by jury. She is Professor of Judicial Studies at UCL, at the UCL Faculty of Laws, and she's Director of the UCL Jury Project. And she's also an Honorary King's Counsel. Now, I'm going to start the ball rolling, and then we'll take questions from the room at some point. We have just over an hour before we break. Just to remind you of the topic, we've been asked to consider what the Leveson report means for the criminal bar, and that's, I'm sure, of great interest to those of you who are thinking that that may be a career for you and wondering what sort of career it's going to be. Of course, the report doesn't mean very much unless it's implemented, put into effect by the government. And we don't know very much about what the government's intending to do. They haven't published their bill yet. They haven't published a white paper. But we do know that as things stand, not all Sir Brian Leveson's proposals have been accepted. In some cases, the government has said, we don't like this. And in other cases, they say, we like it so much, we're going to go even further. But let me start with a short general question to all of you on the panel. It's really this. On the basis of what we know so far, here we are today on the 10th of February, what do you see as the future of the criminal bar? And Mark, I'd like to start with you, please.
Thank you, Joshua. In circumstances like this, there's a great future for the criminal bar. In answer to the question about the review and what the government are doing, we don't know. And it depends. But you're at a point at which a choice to go and practice criminal law is fine. You can pretty much put the government to one side for a moment, because there's going to be plenty of work for the next decade. And in a decade or so, most of the very elderly barristers will have retired. And so there'll be plenty of scope for you all to build careers. As to the detail, as Joshua says, we don't know. It depends upon policy. But we're at a really interesting moment. Could the government possibly do something it's never done before, or no government has ever done before, which is actually to do some joined up thinking? It is in a sense what's at the essence of what Brian says in part 2. We have lost out for decades now because of a lack of joined up thinking. Could we possibly actually try to do that and actually have some management rather than legislation? Because as we all know, in truth, the answer to these problems is never new legislation. It's always better management.
So really what we're talking about is whether the criminal justice system should actually be a system, which arguably it never has been. Wendy, you've seen the criminal justice system, if I can call it that, from the sharp end, from the high judge's seat at the Old Bailey. What do you think of, what do you see as the future of the criminal bar?
I think that's a really difficult question. I wish I could be as upbeat as you are. I'm not necessarily downbeat about it, But I think the future of the criminal bar really depends on the future of criminal justice. And where that's going, just at the moment, I'm really not sure at all. As to what your futures are, that's what you want to know. I think that really depends what you want from the criminal bar, if that's where you want to go. I know what I wanted when I was sitting where you are at your age. I wanted to be addressing juries. I wanted to do jury advocacy. I wanted to take 12 people in my hands and make them believe what I said. I don't think that is going to be the immediate future if this government does what it was saying it was going to do. I have to say, Joshua, and I hate to get political because I know nothing about politics, but I do think the events of the last couple of days, given the strong feeling in Parliament from many MPs against the loss of jury trials, I do think it may be a proposal that gets shoved back down the road a little bit, because it may be that the government doesn't really want to have to deal with that sort of head-on collision just at this moment. But I could be wrong about that.
That's very interesting, and we'll certainly come on to this in detail shortly. But let's just stick to the initial question, and it's over to you, Cheryl. You teach students, and before perhaps they come to the Inns of Court, some of them obviously may be interested in a career at the bar. Some many may not be. What do you see then as the future of the criminal bar?
It is a very interesting and I think a very difficult question at this particular time. For all of you, I'm sure an important factor is going to be the state of criminal legal aid. And of course, Sir Brian has made some recommendations in the report that would be helpful in that regard. But that remains a very precarious situation. So you will have to make some very practical decisions. I would hope that you would be able to be in the situation that Wendy was in, that had the chance to make the decision about whether you wanted to pursue a career of jury advocacy. And I certainly would hope, whether for political reasons, as Wendy mentions, or for other reasons, that the government does not pursue the recommendations for the removal of trial by jury in a large proportion of cases, would continue to give you an opportunity to make that choice, to carve out a career at the criminal bar that is a very distinct career, very different than practicing in civil or family. It is a very unique expertise, I think, to be able, either as an advocate, as Mark is, or as a judge, as Wendy was, to deal with 12 members of the public who did not voluntarily agree to find themselves in the Crown Court, but take their job very seriously, and do have an incredibly important role to play in the criminal justice system, if we have a system.
Mark, I'd like to pick up Wendy's point about the politics of all of this, and just to fill people in on the background. In the House of Commons a week ago today, the Secretary of State for Justice, David Lammy, said that he thought that the legislation that the government was planning and that he was proposing to introduce would become law by the end of this year. And one of his junior ministers said a bill would be introduced next month. And when asked Brian Leveson last week about that, he said he thought the government was planning to introduce a bill this month. But as Wendy says, that was before the events of the past couple of days, although we were beginning to see at the end of last week that things were looking very difficult. Now, you could say that from the government's point of view, assuming that the Prime Minister remains Prime Minister, which is quite possible for the next few weeks and months, that he will want to be seen to be doing a great deal to deal with the problems facing society, and that he will actually want to push ahead with something to resolve the problem that we all acknowledge is a problem, which is the extraordinary backlog of cases awaiting trial in the Crown Court. So it is possible that he'll want to be seen to be very busy. Alternatively, it's very possible that he will not be able to do anything at all, as Wendy suggests. So, Mark, what's been going on since Brian Leveson published the first part of his report on jury trials last July? Because there was a hiatus in the autumn, and we've only just heard in the last few days that the government is pressing ahead with what it says it's doing, and as Wendy says, that may be overtaken by events. What's been going on? What are the pressures, and what do you expect will happen in the coming days, weeks, and perhaps the next month or so?
Well, I suspect all the questions are going to be interesting in that sense, Joshua. What do I think is going to happen? One of the great problems we've had in criminal justice is the pressure that politicians feel to be seen to be doing something. It's the great myth that changing legislation actually matters in the way our country is run and how well it's governed. Management is a far more important skill, and if the systems were managed properly, there'd be much less need for performative legislation. If this Prime Minister wants to be seen to be doing something, he could put in place the administrative work that permits the system to be run far more efficiently, to breaks the silos apart, and means that different parts of the system communicate with each other far more better and more effectively. That is all straightforward stuff in theory that doesn't require legislation. And if it were me sitting there not knowing anything about the inside of government at the moment, I would be thinking to myself, I could actually put together a fantastic package of open public material saying, we've had this very wise former judge set out all these recommendations. This is how we're going to implement them. Meanwhile, we're going to think very carefully about whether or not we should take any drastic steps and see whether it's really necessary to change the right to jury trial. That's what I would do, because the truth of it is that the jury trial proposals, whether you take Sir Brian's initial recommendations or David Lammy's reinterpretation of them, will not touch the backlog. They don't do anything, they're uncosted, they're not properly modelled, and the Institute for Government most recently said they won't help. So they are all gesture politics in a way. And I don't think that's a very sensible way for our country to be run. Does what I think matter? Who knows?
Wendy, you were one of those people, and I think Mark agrees with this, who said that really Brian Leveson had done the two parts of his report the wrong way round. Because we had the jury proposals last summer and we had the efficiency savings and proposals last week. And I think we could perhaps start to talk a little bit about what he proposed last week, if only because poor old Brian, if he's watching this, will want to know that somebody agrees with something that he's said. And so we've got a little bit about that to talk about. I think the most far-reaching recommendation in his report, and Mark has already touched on that, is that the Prime Minister should appoint a criminal justice advisor comparable in some ways to the Prime Minister's National Security Advisor, Jonathan Powell. And this would be somebody who could knock heads together, who could bring warring departments to the same table, to coordinate policies across the Ministry of Justice, the Home Office, other agencies, and make sure that we had joined up government. I'll just mention two more recommendations. His most eye-catching recommendation was that prison vans should be allowed to use bus lanes because of the delays in bringing prisoners to court. I mean, they are buses in a way, but you can't get off at the next stop. This would help that. And David Lammy seemed quite impressed with this. And then maybe the most controversial efficiency recommendation is that convicted defendants who are remanded in custody to await sentencing should be sentenced remotely unless there was to be a victim impact statement in court. Otherwise, it should be the presumption that defendants on remand would appear via prison video link subject to a contrary order by the judge. And he also had in mind that a first appearance by a defendant in custody would be remotely from the police station. Cheryl, can I turn to you about these recommendations? And there are many others which I'll come to. Am I right in thinking that, generally speaking, with some exceptions, and maybe the remote appearances in court are one of those exceptions, that those proposals have been reasonably well received?
Well, I think they've been reasonably well received, but I'm not sure that everyone's had the chance to read through the 2 volumes of part 2. I think I would agree with Wendy that it's unfortunate the order in which the review has been published. If we can agree that there's some very good and very practical efficiency savings, why were they not reported last summer and would be implemented now? I think most people in this room and on the street out there would probably think that prison vans could use the bus lane and that it probably wouldn't take legislation or anything major in order to have that affected. And I think I'm sure Mark would say, and Wendy as well, that would make a difference to efficiencies in the Crown Court. There is, we would all spend time waiting for a trial to happen simply because the defendants were not there. Other things, though, the criminal justice czar, if we can call it that, I think it sounds very sensible. The practical reality of having an individual who would have the authority to bring the heads of different ministries and departments together would be very challenging. That doesn't mean it shouldn't happen, but I don't think we should underestimate the difficulty of trying to pull together and get departments like the Home Office, the Ministry of Justice, the prisons. Also, it's going to have to involve health and education, mental health, all sorts of other aspects of government would have to fall into line, as well as, and perhaps most importantly, the Treasury. Because most of what we're talking about is a criminal justice system that's on its knees because it has been starved of funds, for many, many years by many different governments. But I'll come back to the one other recommendation that you're talking about, which is remote hearings. There's quite a bit in part 2 from Sir Brian about the use of remote hearings and individuals appearing remotely in court in order to make the process more efficient. So for you, thinking about a future in the criminal bar, how much of your time will be spent online versus in court would be an interesting and important issue. There's been a lot of research, unsurprisingly, since COVID in the wider world about the impact of how we interact with each other when we're in person versus when we're online live, or also when we're online recorded. There's been very little work done in relation to how that happens, what happens to people in court. But we know from other areas that one of the things that does happen is we tend to have a loss of empathy when we interact with people online as opposed to in person. And I have a great concern about this desire to push for a lot of remote appearances in court. I worry about the impact on defendants. I also worry about the impact on witnesses. And I do think that that was not adequately addressed.
And Wendy, you've had to deal with this in the real world during COVID particularly.
Yeah. Can I begin with a simple proposition? There is nothing wrong with our criminal justice system. It's a good system. It's been a good system for centuries. What's gone wrong is the way we have been putting it into effect. And that is partly because of inefficiency and largely Treasury driven because of a shortage of money. So that when people start talking about removing jury trials, I think the one thing we absolutely need to get our heads around is no one is saying that gives better justice. It doesn't. What they're saying is we've made such a mess of it and we've got such a backlog that we can't think of any other way of dealing with it than actually cutting out jury trials. And if you read what what Brian says, that actually is there between the words that he uses. That's what's there. So I think that the first thing we really need to do before we start slashing at jury trials is to work out whether we really do need to, which is why the three of us, rather boringly from Joshua's point of view, are all singing from the same hymn sheet and saying, we really need to see how much improvement can be made by efficiency and putting money into the system before we start taking away people's right to jury trial. And I know that Brian says, oh, you know, there is no such right. It's not in Magna Carta. Dear Brian, that is nothing to the point, because the point is, at the moment and for a long time in the past, we have had that right. People have it now. And the proposition is that it will be taken away. And that's serious. That is really serious. So I think that all the things that are in part 2 really need to be looked at before we start taking a knife and stabbing the heart out of the system that really actually is a system the world admires for a good reason. Now, which bits of it are going to work? Which bits of part 2 are going to work? Can I tell you the sort of thing that really troubles me? Mark says we need joined up thinking. I've been writing that in my books for 3.5 years now. We need joined up thinking. But the idea that we get it by having a czar answerable to the government is, I think, a little bit worrying, because governments come and governments go, and they change what they want. And sometimes they change what they want from week to week. And you never are going to be able to get a really independent view across to them. So I don't know what the answer is, but I think it's very worrying that we are getting too tight with individual governments that could change at any time. Look how often we get a change in the Ministry of Justice. How many Lord Chancellors have we had in the recent past? All with different ideas about what should be happening. So I think that something as important as, you're going to hate me for saying this, but I think that justice is too important for politicians, for just politicians. They need to be restrained when it comes to justice.
That means more power for the judges.
That's exactly where I was coming from. You're way ahead of me.
Well, because I'm going to bring Mark in a second, but I need to just read you a few words from Brian Leveson, because, as you say, he is treading a slightly lonely path in this discussion tonight and in the country at large, because the only people who are supporting him are victims' representatives. There are 2 points he makes. He says that more money and efficiency measures alone will not be sufficient to allow the system to operate as it should. To be given the best chance of success, it requires all 3 critical levers: money, structural reform, that means juries, and efficiency. And the sooner all 3 can be implemented, the speedier will be the start of the recovery. And the other point he makes is in response to Wendy's point, which is, why don't we press ahead with the efficiency savings now? Well, if the government is serious, then it can do that, because, as you say, it doesn't need legislation. And we'll see what happens. And if suddenly the efficiencies mean that it's not necessary to bring in the legislation, which wouldn't take effect for a year and a half, 2 years, well, then obviously government can think again. But Mark, I have a lot for you to answer.
3 points, Joshua, I think. The first, in response to something Cheryl said about the digital world and screens. Speaking for myself, if a solicitor has been advising a client in the police station during interview, and then they've been charged and are likely to be remanded in custody, and that solicitor has had time with his or her client and has warned them as to what's going to happen, I have no difficulty with that person then appearing on a screen rather than having to be taken to court, because the human relationship has already been established. Similarly, if I've conducted a trial for a client who's now been sitting on remand waiting for his sentence for some time, and he knows me well and he trusts me, he is not going to mind if I see him through a screen and he is not required to travel across the country in a small trial. There are ways to make all these changes with human empathy, build a relationship and make things work. I've just spent quite a lot of time over the last few weeks speaking to a client in prison in Norwich. And I've been able to build a proper relationship with him. And it's remarkable. You know, I could only have 45 minutes with him if I had to travel 7 hours there and back to see him. So using the screens can be a terrific way to make sure he is having a better experience of the justice system, so long as you do it with thought and care. That was the first point. Second one, Sir Brian is right about many things. I would actually probably agree with 90-something% of what he says in part 2. He is completely wrong about the need for this legislation to change jury trials. And the answer comes with one word: Liverpool. Liverpool doesn't have a backlog. And it doesn't have a backlog because the judges took a different approach to listing. They worked out that well over 90% or so of all possession with intent to supply drugs cases pleaded at trial. If you say to everybody charged with that offence, you're going to be tried in 2 to 3 years' time, of course they plead not guilty. Because that's what you do. How many human beings do you know take their head out of the sand and decide today is the day I'm going to give up chocolate, smoking, or alcohol? We are not very good at that. A problem adjourned is a problem solved. A problem put off to another day when we're going to take exercise again and eat vegetables another day. And that's what all defendants do. In Liverpool, they worked out that if they gave everybody facing those offences where they pleaded guilty a trial date in 6 weeks after the initial hearing, everybody suddenly realised they would lose all their credit if they didn't plead guilty immediately. And it changed the culture. It changed the culture, and the backlog disappeared. What it needed was terrific judges managing in a court centre where there are a lot of local barristers, everybody knows everybody, there's a sort of communication culture that works, and they had the courage not to kick off those sorts of cases behind all the other ones where nobody pleads guilty. So I would stand with the victims lobby who say the current system is not serving us properly, but it's partly not serving us properly because if you fill every court with the kind of case where nobody ever pleads, then all the other ones who are going to plead eventually follow human nature and they say not guilty. That's the half of the solution under Liverpool, is the opportunity to plead early. And it would, I am completely convinced, and I think every barrister you spoke to who's thought about these issues would say the same thing, solve the problem. The other problem is something Brian does intend to touch on, which is incentives to plead. And there are a series of things. One of the things I've been trying to persuade the Home Office to do for about 15 years now is to wrap up financial settlements, confiscation at the point of plea. Because the police usually know enough about people's bank accounts to know whether or not there's any money left. And the legislation makes that very hard on them. But if you start thinking about incentives like that, suddenly it becomes advantageous to human nature to want to plead guilty if you think you're going to get a proper discount. And I think the problems can be solved in that way. The third point, forgive me for going on so long, is culture. And it's how to help each other. I actually agree with Wendy about the dangers of investing this in one person, one czar. But can I give you one example from the midst of the pandemic and the misery we all faced as to how to make the system work here? It's called the Crown Court Improvement Group, brilliantly run by the then senior presiding judge, and then taken over by the next one. And those two senior presiding judges sat with all the different agencies and people like me, who's then chair of the bar, representing all the different actors within the justice system. And the culture of those meetings was you read everybody else's papers and you think in advance of those meetings what your part of the system can do to help the other parts. So we got the prison people putting in place their memos about the complexities of how many video booths we do or don't have. And then the judges saying, well, that's a problem for us because of this. And the barristers and solicitors saying, well, that's a problem for us because of that. But all looking to try and find ways to help the other parts of the system. And it fostered a culture where all of a sudden you're not looking to say, well, it's not my fault, it's his or her fault. That's really, really difficult to do when politicians get involved and point scoring is the order of the day. And that's why actually, while we have to accept that notwithstanding Wendy's wisdom, it would be lovely if justice was left alone by the politicians, it never will, because it's one of the great blood sports of this country. It entertains the media, it entertains everybody else sitting in licensed premises, having an expressing an opinion in student halls up and down the country about justice. But if we could find a way to create that sort of encouraging culture, it sort of captures, in a sense, what we ought to be doing as a society, rather than just saying, well, let's ask a czar.
Let's move on to some of the details now. And this takes us back to the first part of Brian Leveson's proposals. I think we can all agree that jury trial has developed into the best system we have for trying serious crime. Equally, we accept that most crime is dealt with in the magistrates' court. What, 90%, Cheryl? So what we're discussing is thresholds, where you draw the line between cases tried in the magistrates' courts and cases decided in the Crown Court with a jury. And as everybody here knows, there are either way cases where the defendant can elect for trial by jury. And the question is, who should decide whether that defendant is tried by jury, whether there should be a right to elect, is that right to elect sacrosanct, or whether the decision on whether a person is going to be tried by magistrates should be made by a court, by magistrates, by a district judge. And I think even the Bar Council accepts that some cases, which currently either way, could be made summary only, which would mean those people would lose the right to trial by jury. So are we all saying that, subject maybe to a few cases which are knocked down to summary only, and we can talk about what those are if you like, nevertheless, the defendant should be able to retain the right to elect trial by jury in all cases where the defendant has that at the moment, or, as Brian Leveson suggested, that right should be limited, or, as the government says, that right should be taken away from defendants completely, and all such cases should be decided by a court, by a judge, by a magistrate, rather than by the defendant. Cheryl, do you want to start with that?
It's a big question. I think I'll come at it this way. Wendy was right in raising the question of whether there is a right to trial by jury. Of course, it's limited by legislation, but I think one of the interesting parts about this is, what does the British public actually think about the place of trial by jury? In reality, yes, most of our criminal cases are not decided by juries. But the last time we were discussing whether we should have a Bill of Rights in this country, there was some very interesting research done all around the country. Many different members of the public took part. This was done by the Roundtree Foundation. And they wanted to identify what rights the British public felt should be in a Bill of Rights if we were to have one. And one right came out top, and that was the right to trial by jury. And I think that, Sir Brian, the government, others who would be supportive of these changes really need to bear that in mind. It's one thing to say there's no constitutional right to trial by jury in this country. Magna Carta doesn't set it out for us, but we have a British public who are deeply attached to the idea of trial by jury, even if it is for only 10% or less of our criminal cases. So I think that you tread on that at your peril. And I think perhaps what I can share with you, I'll leave to Mark and Wendy perhaps to talk about where the dividing line should be. But I will share with you the fact that I've spent 20 years doing research with real juries at court. We have looked at all aspects of how juries work, try to identify whether there are problems with fairness, with effectiveness, with efficiency. And I can tell you that I've been looking for problems with juries for 20 years. And actually what we've discovered is that juries are one part of the criminal justice system that actually work, that they're fair, that they treat defendants, regardless of what their background is, equally, that they're also effective and efficient. And so I find it quite ironic that the one part of the criminal justice system that does appear to be working is what's in the firing line for being cut back.
Wendy.
Yeah, the question you asked, Joshua, I think, was should it be retained for all cases where we have it at the moment? I think it's important to say where we have it at the moment is not where it's always been. It changes, and there's no reason, I mean, there's no point in sticking our heels in the sand. It does change. In the course of the time since I've been at the bar, and ladies and gentlemen, I came to the bar in 1975. There have been a number of changes, all in the direction where there is no right to elect now where there was in the past. So I'm not saying that you cannot change that. If you're trying to find the place where you are going to change it, though, to, if I may coin an expression, do a Lammy, is, with the greatest respect to Mr. Lammy, not the place to start. You just can't say, because the likely sentence is going to be no more than 2 years or no more than 2 years and 3 months, you can't have a jury trial. And you've only got to stop and think about the ramifications of that. Sometimes you don't know what the likely sentence is going to be until the judge hears the facts of the case. Things can look very different at the end of a case than they did at the beginning of the case. So I think all of these things are difficult. And what doesn't seem to have crossed Mr. Lammy's mind, and if you read Brian's reports, you would think it hadn't crossed his mind. But I know Brian, and there'll be nothing that hasn't crossed his mind. You don't have to draw the line with the length of a sentence. There's all sorts of different ways you could draw that line. You could, I wouldn't be in favour of it, not in favour of what's being proposed now, but you could draw the line where people have got 1 previous conviction, or where they've got 5 previous convictions for the same offence. You could draw the line when you're looking at personal circumstances. But to draw the line simply because of length of sentence, or likely length of sentence, even worse, is so dangerous. And the sort of example that you will have heard many times is supposing one of you were charged with shoplifting, and you know you didn't do it, and your whole life, your whole future depends on the verdict, because if you are convicted, you're not going to be called to the bar. So there are many, many people for whom the consequences of a conviction far outweigh the consequences of the actual sentence. And I do say, with respect to Mr. Lammy, it's naive to think that the place where you draw the line can only be on length of sentence.
Well, what Wendy's moving on to talk about is the Crown Court bench division, which is the idea that people would be sent for trial in the Crown Court, but their cases would be heard without a jury. Now, Brian's idea was that there would be a judge sitting with 2 magistrates, and we don't know what level of judge it would be, but I suspect it could be any level of judge. It's not clear. And the government's idea is it should be a judge sitting alone. Whether that's because they can't find enough magistrates, we don't know, but that's obviously a factor that they're considering. And then one of the questions is, if we get this far and the bill gets to the House of Lords and it runs into trouble, that might be a concession that the government might make in the future, bring back the idea of magistrates in the Crown Court bench division, which at least gives a lay element to the system in the Crown Court to replace trial by jury. So, Mark, and I'm going to bring in the audience after you've answered this question. This is what do you think of what the government is proposing on juries, and indeed what Brian was suggesting on juries?
So what I would plead to happen would be for an evidence-based, rational assessment of what will work, what won't work. And that's not what we're getting from the government on any view. I'm going to come back to the detailed proposals and the two different alternatives in just a second. I want to, if I may, just deal with thresholds, because it's a legitimate debate to have. There's one offence that cries out to have either way status removed and made summary only, and that's called assault on an emergency worker. It was brought in by, I can't remember which government, who was trying to apologise to the Police Federation, as far as I can tell, for not funding them properly. So it thought by creating this offence, it would somehow curry favour with the Police Federation. You will all know that there's already an offence called an assault of a police constable, an execution of his duty, which has a perfectly adequate 6-month sentence. I would imagine that almost all the assault emergency worker offences are actually on police officers. And everybody's thinking, as a way to make the police happy, we have this because it's got a potential longer sentence. What's the consequence? The consequence is everybody elects trial and they get kicked off into the backlog. The last two resident judges I spoke to in great detail about this in the middle of 2022, they've done some detailed triages of their backlogs, and something like 15% of their backlogs were assault emergency work. It's a nonsense offence to have in the Crown Court, in my personal opinion. You can sentence somebody perfectly adequately in the Magistrates' Court, raise 12-month maximum if you must, the list of aggravating features. Most of those offences are committed while people are wearing body-worn video. If they were in the Magistrates' Court, everybody would plead innocent. And we wouldn't have an extra 15% of cases in the Crown Court. Why am I telling you this about threshold? Because that's a good example of something which, if I were in charge, I'd be saying to the government, the only rational way that's not playing politics is to do all of the efficiency savings, make some tweaks to the current system to de-escalate, to take out of the Crown Court stuff that really shouldn't be there and was put there for the wrong reason. Have the courage with your big majority to bring it back to the Magistrates' Court, resource the magistrates better, employ more district judges if you need to, have enough court staff there, but de-escalate. And that will begin to take all the pain out of the backlog in the Crown Court. There's another important thing, if I may just, Joshua, on the same point. There's a whole sentencing bill coming into force at the end of March. I'm sure you all know that there is going to be a presumption in place that all sentences under 12 months should be suspended, unless there have been previous breaches and so on and so forth in court orders. According to the government's own fact sheet, when this was published, 62% of everybody in prison was serving 12 months or less. Imagine what that will do to the prison population if there's an impact. All of a sudden, all of those sentences come out of the prisons. This is why it's important. Over 50% of the MOJ's budget, I think it's 53, 54%, goes on prisons. The tail wags the dog all of the time. Prison populations are what drive all policy, because that's where the expenditure largely is. If they've had the courage to put in place this change, get the efficiency stuff going, and let's have a measured, balanced, non-political debate about how we de-escalate and take some offences out of the Crown Court and into the Magistrates' Court. Because then you don't need to worry, Joshua, about whether a judge on his own is better than a judge on her own with two magistrates or not, in a completely uncosted, untested way. I know from private conversations with every Crown Court judge friend I have, none of them want to do it. They can't speak for themselves. Not one of them wants to do it. Not one of them thinks it'll be quicker. Not one of them thinks it'll be better. Now, none of them can speak publicly, and I would never breach any confidences about that. But don't do something without an evidential base. It's untested, unmodeled, and it's just purely for we must be seen to be doing something. When there are rational, fact-based things you can sensibly do, which we've shown already will make a difference.
And at that point, it's over to you. So, ladies and gentlemen, and also those of you watching online, time for questions. Ideally based on what you've heard so far, but in particular, if you want to, on your own career prospects, your own career concerns, your own hopes and fears for the criminal bar, if that's one of the areas you're thinking of practicing in. It's always difficult being the first to ask, but you have to be bold if you want to be barrister. So, who's going to ask the first question? There's a roving mic that Tony has here. Right, lady in the front row and then the lady over there. But you first, please. And just wait for the microphone to come to you, please. Thank you. And you're welcome to give your name, but you don't have to.
Hi, my name is Nia. And I'm sorry, maybe this question I've not really articulated in my head properly. But talking about the backlog of cases, in Manchester Crown Court, there's like the backlog is heavy and it's bad. But then you also see that there's a lot of courts, like rooms that are already closed, and judges are in their chambers. They are not doing anything, where they could probably not to be disrespectful.
No. You're talking about the cap on sitting.
Yes, they could be judging a case where the court is probably closed because they're trying to save cost.
Yeah.
And I think my question is, instead of probably funding these things, right, to get judges who are readily available to come into court to judge these cases, like, why not basically think about that first before going to take trial rights from the tribunal of facts? So
Okay.
question. We all agree with what we want to know
about that.
None of us have any doubt about that at all. We know that courtrooms are closed because the roofs are leaking. Jurors can't sit because the lavatories are all blocked up, and judges can't sit because there aren't enough sitting days. We all know this. It's just that Mr. Lammy doesn't seem to know it.
Well, that's probably true, Wendy. I do want to raise one other thing, though, about the backlog. You said, well, you've been in Manchester, backlog's very bad. There are over 1,000 pages in both Volume 1 and Volume 2, Parts 1 and 2. In that report, and I cannot find it online anywhere, I would like to see a table that lists every single Crown Court and the number of cases that are in the backlog. And I would like the resident judges in those courts to be able to certify whether those are the numbers, because I have also heard that there is some misreporting of the numbers. And I want to pick up on Mark's point, which is Liverpool and a number of other Crown Courts which do not have a backlog. So why, in all of this, extensive amount of work that went into the review, and I'm sure a lot of work went into it, why we do not have the basic amount of information available to us in order to make an assessment? There's also been no economic analysis of any of the recommendations. We have heard that there will be some kind of impact assessment when a bill is published. That's too late. And also, that's going to be done by the Ministry of Justice. And pretty much all of the data that is in Sir Brian's volumes has come from the Ministry of Justice. It is not independent analysis. We have not had an independent analysis of the proposals, of the economic impact of those proposals, and of what you are suggesting, which is, why do we not invest in the courts, in the sitting days, in legal aid, so we've got enough criminal barristers who are actually able to run these cases? And can we please have a proper independent economic analysis of the proposals that have been put forward?
Mark.
Can I reassure you all in a sense that people like me have been saying something very similar to what Sharon has just said to government ever since we've had access to. My first attempt at doing this was when I was still a junior and I was helping the CBA respond to the then Lord Chancellor Chris Grayling's proposals back about 15 years ago. And it began a process of begging the Ministry of Justice to get proper data. Before I develop the theme of data a little bit more and tell you just a couple of tiny war stories about the pandemic and data, I want to make sure you all understand the concept of the sitting day. The sitting day is the currency by which the Ministry of Justice controls its spend. Because for every sitting day, there's a notional cost. A certain number of people go to prison, and there's costs of probation, there's costs of legal aid, there's other things. So it's the only way they've found so far to try and manage their budgets. But it's really, because they're responding to demand that comes in with inputs into the system, it's a really rough tool. And so if they've spent a bit too much, they turn down the tap. They control the number of sitting days. At the moment, the courts are pretty empty across the country. And they're empty because we're approaching the end of the financial year. And the people who control the money, whether it's in the Ministry of Justice or the court service, are not listening to the victims' lobby because they're saying, well, we've got to control our budgets because we'll be in trouble with the Treasury if we don't spend this. So the truth is, the backlog is a political decision. And it's the consequence of political decisions that have been made now for 15 or 20 years. It's why I've got this plea constantly going on for data. Let me give you two little war stories. At the depths of the pandemic, when it first struck on March the 22nd, it's engraved in my heart for a whole series of reasons. I was leader of the circuit, and I, with the other circuit leaders, started talking to our respective resident judges about what we could do. And it began a year when we did nothing but have endless Zoom calls and Skype calls when it still existed about trying to restart the system. What did we discover? We discovered that HMCTS data about the backlog was deeply flawed. They had no idea. They particularly had no idea about the nature of the cases they had there or the number of defendants. Why did that matter? Because you couldn't have multi-defendant cases through the pandemic because all the distancing rules, you know, in the absence of perspex, so don't supermarkets first and all that sort of thing. Who did have proper data? The CPS had much better data. And so I and others put together a program with the chief crown prosecutors who were collating their data and beginning to compare it with what HMCTS had, which was so poor. It wasn't poor because they're bad people. It was poor because they'd never been asked to collect it. HMCTS is one of the least well-resourced parts of government. People who get good at their job there tend to leave to go somewhere else in government to other jobs because they're better paid elsewhere. So there's a loss of experience which no private business would ever countenance. They'd never been asked to record this data. It wasn't there. The CPS data was better. The best data came from the resident judges. They don't have the support they should have had. They didn't have the number of staff they should have had. We've been pleading for support for judges, better support for judges for years. But dedicated resident judges sat endlessly through that deep, dark year of 2020, measuring their cases, counting it up. And the combination of data from the judges, the CPS and HMCTS, meant that we had a better way to respond and to consider the political processes to get the courts moving again, with the nice cap groups and the distancing rules and everything else. But the plea is always to look for the numbers, look for the data to get away from people just claiming that an intuitive political decision, uncosted, unfunded, will somehow ever suffice.
Okay.
Sorry.
That's all right. No, it's fine. There was a question over there from, I think, and then there's a gentleman at the back. So, yeah, and a couple online. Right, go ahead.
Great. Thank you all for your insights so far. My name is Saskia, and I'm actually a former student of Professor Thomas's Judicial Studies class, so full circle. I just wanted to turn back to the backlogs quickly and focus on a bit of the stagnant population. I attended a fireside chat hosted by Professor Ormerod recently, and there was a quote from James Timpson MP, and he opined that 2/3 of the prison population could be released right now, 1/3 with no further community support, 1/3 with community support. And I'm just wondering, in terms of the legacy of the IPP regime, whether anyone had any thoughts on the fact that it's been renounced but not really rectified, and any thoughts on IPP in general and what impact that could have on the backlog.
Okay, fair enough. I'm going to take the gentleman at the back, and then I'm going to take the two questions online because we're rapidly running out of time. So IPPs, perhaps not, well, I mean, it obviously relates to the backlog, but it's possibly not quite what we're talking about. But anyway, go ahead, sir.
Thank you very much. I'm very happy that we're having this discussion. But when I'm watching the TV, when I'm listening to political podcasts, I see quite different story, quite different narrative in the political universe. I think the dynamics and direction where this country is going will be, at some point, it will be quite possible that the government will start considering leaving the European Court of Human Rights, the convention. At the same time, it is quite possible that at some point the mass immigration bill will be a reality. What do you think is waiting us? Do you think the criminal justice, the legal universe will be affected by these changes? Thank you.
That's another very broad question. Tony, I'm going to get you to read out the two questions online.
There's a lot more than two.
Oh, really?
I'll choose two very.
Read out two or three, and then we'll have a round of answers from the panel and see how much we get to.
So there's a couple here which are very good. I prosecute and defend. I'm a barrister who converted from being a solicitor. There's lots of research being done on Crown Court efficiency and inefficiency, but should the focus also be on other parties within the system, such as the police, CPS, and solicitors? A lot of court time is spent on carrying on with cases that is policy-driven rather than evidence-driven.
Okay, I'll just, while you're getting to the next one, I'll just read out half a dozen recommendations from Brian Leveson in part 2 of his report, which sort of deal with that point, and then we'll get one or two more questions from the viewers at home, as they say. One of his recommendations is about legal aid. It should include an annual review of fees and a new staged payment system to incentivize earlier engagement. He says the police should no longer have to redact personal data before sending case files to the CPS. Listing officers should be paid more to recognize the importance of their role. New criminal procedure rules should be drafted so that they can be easily digitized in future. Lawyers should have a standard way of emailing courts so that they can contact judges on administrative matters, timings, adjournments, and so on. And professional witnesses should be able to give evidence by video link. So I just wanted to mention those as examples for the question online. And then do you want to read out one or two more?
Yes, there's whilst we're focusing on the criminal bar particularly, I thought this one's quite interesting. A big difficulty for junior practitioners is not insufficient pay per se, but delay in getting paid. I was paid £60 today for a youth court bail hearing I did in 2022. I listed a trial yesterday for 2029. I'll not be paid until its conclusion. Instead of more pay, why is there not more focus on faster pay to incentivize practitioners to prepare cases early and guard better listings? And to guard better against listing too many cases in a barrister's diary.
Okay, Mark, I'll come to you on that particular point and perhaps some of the other points that were raised so far in the questions we've had so far.
Dealing with the faster pay point, it's actually done pretty well by the legal aid agency when you come to the Crown Court. The Youth Court and the Magistrates Court is an entirely different matter, and there's some difficult challenges around that frankly is beyond the scope of this forum to try and address. But it's exactly the kind of thing, to anybody listening online or you're thinking about, that you should always bring up with bar leaders, with heads of chambers, with if you're working for solicitors firms, those kinds of issues, because there are ways to mitigate that kind of problem. Speed of payment is not a problem generally once you're engaged in a case at trial or they're pleading guilty at the Crown Court. There is an issue emerging about these long delays, but it's actually, I think, within the scope of the profession, the legal aid agencies sort that out. Probably. Can I say one thing about digital advocacy and this whole and the recommendations? There are two different ways of doing this job. We all know it's a face-to-face profession, and the ideal for anything substantive is face-to-face. But increasingly, much more is going to happen online. The way to present online is very different. You have to prepare differently, you speak differently, the cues are differently, the sequence of speaking is different. I actually think it's something I've discussed with Tony. It's an entirely different discipline that should be taught. You all know it from every online meeting you've ever had. In online meetings, everybody takes turn, there's some chat log, it's all very routine, they generally finish. In face-to-face meetings, things happen. You learn new stuff, you build relationships. There's a humanity around it that is infinitely better. And I think through your careers, if you think about it and you're going into it, always put your hand up and say, I'm doing this one this way. Can I do this way? Is it actually capturing what I need? Keep asking the questions to the people you're studying with whenever you're involved in advocacy training of any sort, because I think there's a future line of training that we ought to be adopting in order to meet Sir Brian's recommendations, because there will be far more stuff online in the future.
Wendy, that's your topic really, training and how to.
Well, it used to be once upon a time.
Yeah.
Yes, it's true. With apologies to Cheryl, I'm actually a fan of using remote court hearings in the right context, not in the middle of a trial.
Exactly.
Not in a jury trial. And I don't agree with the report's proposition that experts and police officers can all give their evidence online. But it seems to me that really, with the proper conference online facilities, video facilities, there is no need for any defendant to be brought to court for anything other than a substantive hearing, a proper hearing, a trial hearing. Of course, there will be exceptions. If a barrister says, look, I really need to talk to him and I really just need to sit down in a room with him, trust me, judge, on this one, it would be a foolish judge who didn't trust the barrister on that one. But by and large, I think that we could get rid of a huge number of hearings by increasing the video facilities. And I feel quite strongly about that. Mark is absolutely right. It's a different technique of advocacy, but it's still advocacy. So you just need to work out how to make it work for you.
Cheryl?
Yeah, can I just say, if I wasn't clear before, I wasn't suggesting that there shouldn't be remote hearings. So much of what happens in the Crown Court prior to trial can be conducted remotely, and also the efficiency for you. You can appear in 3 different Crown Courts in one day dealing with hearings, and you're not hopping on the train and so on. That's not an efficient use of your time as an advocate. But I agree completely with Wendy. The issue, I have a concern about the push for the issue to use remote witness statements and defending giving evidence remotely, but particularly witnesses. And there are sometimes very good reasons for it. We've introduced that for individuals who are involved usually in sexual offences cases or for children, to try and enable them to give their evidence very quickly and then not have to deal with coming to court. I think that we need to tread very carefully with that. We need to have a much better sense of what the impact is, not just on the jury. If these cases become trial by judge alone, we don't know what the impact is on the judge from hearing, perhaps the defendant is there in person giving evidence, but the main witness is not. What's the relative impact on that? But I do want to pick up on one of the questions that was online, which was about why all the focus on the Crown Court. It is a very good question. We're talking about the review of the Crown Courts, but it's almost impossible to talk about the review of the Crown Court without talking about some type of assessment of what's happening in the Magistrates' Court. I find it quite puzzling that we are talking about the extraordinary backlog in the Crown Court, the number of which I'm still not sure of. It seems to be changing all the time. It may be getting up towards 80, 90,000 cases, but there's very little mention of the fact that the Magistrates Court has a backlog that's getting up to 400,000 cases, but we don't seem to be concerned about that at all, which I find quite perplexing. And yes, I think you raised a really important point, Joshua, about there's been a lot said about the need to address the backlog in the Crown Court to deal with victims who are waiting a long time, particularly claimants in sexual offences cases. They can't get on with their lives while they're having to wait 3, 4, 5 years for a trial. The reality is that their big wait and their big disappointment is from the point at which they make an allegation to the police, and whether that's ever going to result in a charge, and how long they will have to wait before that charge happens. And there's some facts that seem quite often to just simply be overlooked, which is that in rape cases, which are obviously one of our most serious cases, when those cases do get to trial in the Crown Court, and they will remain before juries, even with all of these proposals, juries are far more likely to convict than they are to acquit. We now have a 73% conviction rate in rape cases, and that's probably going to surprise many people in this room, because what we hear about is 1, 2, 3% of rape cases result in a conviction. That's because the problem is at the level of the allegation that's made to the police that never results in a charge. So.
Have we got one more question from here? We will have, gentleman here and then the lady here, and that's almost it. So briskly and briefly, if you'd like to ask your question, please. Yep, and then I'll continue.
Good evening. My brisk question is there a single structural reform that you would propose to achieve better quality justice? If so, what would that be? Or is our system really as good as it possibly can be already?
Okay, that's good. And then I'll just take the question over here. It was the lady here, yeah.
Hello. I was really interested to hear about the regional variations of the backlog in the Crown Court, so contrasting from Liverpool to Manchester. And it made me wonder, could there be any increase in efficiencies with a bottom-up approach rather than top-down approach?
Okay, so there are two questions on what you would do. And of course, it's interesting that Brian Leveson himself comes from Liverpool and practiced in Liverpool. His point, which he summed up very well, is, if not this, then what? That's what he said at the briefing that he gave a week ago to journalists. So there you are. If not this, then what? Quite a short answer from each of you. Oh, I don't know who I'm going to start with. Wendy, why don't I start with you?
The question that you asked was a very interesting and carefully worded question, because what you were asking about was whether there was a single structure and reform that would improve the quality of justice. What is being proposed in these papers is about getting rid of a backlog. Perhaps we are saying at the expense of the quality of justice. So I'm not going to sit here and say I've got a single structural reform, but I cannot plead strongly enough for the need to try and work out what the problem really is before we actually try and solve it by getting rid of jury trials, and we won't know what the problem is until we get the data and until we actually make efficiency and people put money in to do the things which are quite simple to do with a little bit of Treasury support.
Cheryl.
I'm going to answer it kind of in a reverse way, which is to say that perhaps just consider how many other jurisdictions have trial by jury. Do they have a backlog problem? Is there cause and effect? There does not appear to be cause and effect. So that is a major structural change being proposed with no guarantee that it will solve the backlog. And in fact, I think pretty much now everyone's coming to the conclusion that it will not in itself solve the backlog. And I do agree with Wendy. It's hard to talk about one single structural change, although perhaps the word structural is incorrect for my answer. Yes, there is one change that could happen that would improve the backlog and improve the quality of justice, which is to fund the criminal justice system the way it needs to be funded.
Mark.
Every other jurisdiction I've travelled to, and there have been many over the last 5 to 8 years, has a problem with backlogs because of political decisions not to fund their judiciary properly. In most countries around the world, that's because increasingly authoritarian governments don't want judges to be making independent decisions, and they're not paying attention to most of the people who are in their courts. Thankfully, I don't think we have quite that problem here. But making these changes to the jury system, I'm not going to touch the backlog, not make any difference at all. My plea, if I've got one, is for joined up thinking based on proper data, which actually then means you learn from experience about what works and what doesn't, which is why the regional variations and what we've learned about the bottom-up approach can work. The challenge we all face in our society is that increasingly, what used to be the circus maximus now takes place on everybody's phones. And politics is being mediated in a different way. And politicians are trying to stay ahead of society in that way by making noise and finding ways to stay ahead of them, keeping everybody's attention on them. So they're saying we're doing something. And the skills of management that make complex systems work better don't reduce very well to short videos or clips on whatever your preferred social media system is. They're not easy vote winners, but it's the kind of grown-up government it would be really nice to have.
I think we've had a very rewarding evening. Your reward also is going to be outside this room, where there may just be the odd drink and perhaps even something to eat. But before we end, I'd just like to thank our panel. From the far end, Mark Fenhalls KC, in the middle, Her Honour Wendy Joseph KC, and nearest to me, Professor Cheryl Thomas KC. Thank you all very much indeed.